Glacier Northwest versus Teamsters. This is another one that could have been
worse,
much worse. Yeah. Well, could have been. I don't know. You characterize it because I feel it's bad, but and I think it is a sign of things to come. But it's not as bad as it could have been.
Yeah, it could have been catastrophic, and instead it was just awful. That's how I would put it. This is a case that was teed up as a direct challenge to the federal right to strike, which is something that the New Deal protected very vigorously. We passed the National Labor Relations Act, which guarantees employees the right to organize collectively and go on strike when they see fit. And one of the key safeguards here is that the federal law that protects the right to strike generally supersedes any state level efforts to punish a union for organizing a strike. So that sounds very abstract, but think about it this way. If states could allow their laws to be used against unions every time there's a strike, then the employer would simply walk into a state court at the beginning of a strike and slap the union with a million different lawsuits: negligence, recklessness, conspiracy, fraud, trespassing, destruction of property, whatever. And they would just drown the union in lawsuits that would prevent the union from ever striking in the future and from organizing an effective strike. That is how unions basically worked before this law, and it was a nightmare. So the federal law says not only do unions have this right to strike, but the federal government generally supersedes state authority to attack unions as long as that strike is arguably protected by federal law. So as long as the workers are engaging in a kind of conduct that is arguably legal and arguably protected, they cannot be slapped with civil suits. Their unions cannot be slapped with civil suits. It is the National Labor Relations Board of the federal government that has jurisdiction. They step in when there are complaints. They resolve unfair labor charges. They are the ones who deal with this because, again, otherwise unions couldn't function. They would just drown in lawsuits all the time. So this is a case about truckers. They drive the cement trucks that you see on the streets. They decided to go on strike. Their employer would not come to an agreement at the bargaining table. They went on strike after their trucks had been filled with cement, and they brought the trucks back. They did not try to destroy the trucks. They didn't try to destroy the cement, but the cement was ultimately ruined because the strike had sort of lengthened the timeline, and by that point, the cement was too hard to be of use. So
and to be clear, they left the truck spinning. I mean,
they left the truck spinning. The drums were running. The employees did everything that they could to protect this cement, right? They took the trucks back. They left them running. They just couldn't protect the cement because it's a very, very tricky business and it hardens very fast. So the employer steps in and sues the union and says, you organized this strike and this strike destroyed my property. And the Washington courts say, well, this is not a case for us. This is a question for the National Labor Relations Board, because clearly this conduct was at least arguably protected by federal law. And the Supreme Court reverses by an 8-1 vote. And the Supreme Court says that what the truckers did in this case, their strike, was clearly illegal and not even arguably protected because they failed to take reasonable precautions to protect their employer's property. And because of the lack of those precautions, they opened themselves and their union up to state level lawsuits, and they get no protection from federal labor law. And only Justice Ketanji Brown Jackson dissented from that decision, which I thought was a pretty big shock.
Okay. All right. So I want to go through the sort of like the two different, the Coney Barrett authored decision and the sort of like adjoining decision in favor of the same outcome. I want to get to that in a minute, but it seems like there's no way to get around. Like, it seems like in every instance, because of this, you'll be able to sue a union in state court, because if you're ignoring the arguability that this was not a problem, like, right? I mean, the way that this should have gone is the state court goes, we don't have jurisdiction here because it's not obvious what they did. It's a question of, is leaving a cement in a cement truck spinning around like this, like completely reckless. And, as opposed to, we took the trucks and we hid them and we didn't tell you where we left them. Like we went on strike en route to the job, and where the truck is, you're going to have to find out. That to me seems like, okay, you're really being reckless with this. But this is arguable, right? I mean, like, it's written into the law. Like, what is arguable? Well, whether it's, not a slam dunk. And in this instance, it wasn't a slam dunk. The National Labor Relations Board could have found, like, yeah, we don't like this or whatnot. But we talk about the other cases like milk and cheese and stuff like this that have set the precedent that this is judged against. And had they found that it was arguable, they would have inhibited the state court case going forward, and the National Labor Relations Board would have made a determination.
Yeah, and to be clear, the National Labor Relations Board has already stepped in here and accepted the charge of an unfair labor practice. And something that Justice Jackson says that I think is clearly right is, if the NLRB thinks that there is something here, that there's smoke here, that should be enough to say that this is arguably protected, because they're the experts and the ones tasked with doing this under the federal law, not us. But to your broader point, there are all of these cases involving perishable goods like milk and cheese and yogurt and fruits and whatever that are in the hands of someone who is shipping them to their final destination. The shippers go on strike, and ultimately the cheese or milk or whatever spoils and is useless. And in all of those cases, both the NLRB and the courts have found that those strikes were protected. And they found that because the whole point of a strike is to hurt your employer's bottom line, to show them how valuable you are as a worker and to force them to come to the table and negotiate. Like, the purpose of a strike is to make your employer feel the pain and the burn of you walking off the job and really using the leverage that you have as a cog in their machine to force them back to the table. And Justice Jackson has this great section where she says, employees are not indentured servants. Employers are not their masters. Like, they do not owe free labor to their companies. Like, they get to strike under federal law. And if that leads to the destruction of some products, whether it's milk or cheese or cement, that's how it works. That is the choice that Congress made when it passed the National Labor Relations Act. And the court just totally chucks that principle. This is the majority opinion. There's a 5-justice majority opinion by Amy Coney Barrett. She just chucks that principle. And she says, well, we're not going to credit the truckers for refusing to steal their employer's property. Yeah, they could have driven the trucks away. They could have hidden the trucks. They could have destroyed the trucks. But, we're not going to credit them for not doing that. They also should have refused to load the cement into their trucks, knowing there was a chance that they would go on strike and the cement would be ruined. And that just has it backward from all of the case law, from the actual statute. That is not how strikes work. That is not how the right to strike works. And so this is a real blow to workers' ability to actually collectively strike when state courts are going to open themselves up to endless lawsuits filed against unions saying, well, you didn't take the right precautions, so now we're going to bankrupt you.
And it's going to expand what taking the right precautions means, right? Yeah. I mean, it could be like you decided to strike in late November. Christmas is the season in which we make all our money, and you did not take the precautions. You should have striked in June, because Christmas is when we make our year, and that's not fair.
That was kind of the justification for, by the way, breaking the rail strike a little bit, because it was just too crazy of a time. But I would imagine that they employ that kind of thought going forward legally, which is what's concerning. Someone's gonna test it, right? I mean, that's what's gonna happen next. Is some employer is going to, or some, the American Enterprise Institute or the Heritage Foundation or whatever that legal entity is gonna find a plaintiff who's gonna try and make that argument, at one point or another.
Yeah, and this case comes out of Washington State, which has like the bluest courts in the country and very good labor laws. Imagine what happens when this fact pattern plays out in Texas or Florida or a state with terrible labor laws. Like, this is a real existential threat to unions in a way, because any grocery worker, rail worker, retail worker, whatever, we could go down the list. Like, there's always some reason why they shouldn't strike at this moment because it'll hurt their employer's bottom line. And what Justice Jackson says that the majority just rejects is that's the point of a strike. And if we take that away, then the right to strike no longer exists under federal law.
All right. I want to get into the aspect of Ketanji Brown was the lone dissenter, but there were sort of two camps in the decision, and Sotomayor and Kagan signed on to the Amy Coney Barrett decision. Will you just sort of like parse that out for us, like what those two camps who all signed on to the outcome of the case versus sort of like the reasoning behind the case and what the implications of that are?
Right. So the majority, Amy Coney Barrett, along with Sotomayor, Kagan, Roberts, and Kavanaugh, they take what the media called a middle ground or a compromise, where they zero in on reasonable precautions and say, this is just a case about how they didn't take reasonable precautions, so they weren't arguably protected. So let 1,000 lawsuits bloom. Gorsuch, Thomas, and Alito are off in a kind of separate world where they say, yeah, we definitely want to stick it to the union here, but we would also like to overturn all of the precedent that protects strikes as long as they are arguably protected, and dramatically cut back on the amount of federal safeguards that we have for striking workers and their unions, and really make it so that unless a union's conduct is 100% obviously protected from the start, that state courts can open their doors to lawsuits, which is not a way to actually implement the National Labor Relations Act. It goes against the text and like a century of precedent. And it means, if put into effect, that unions are going to get slapped with endless suits because, you can never prove that something is obviously clearly 100% protected. That is a fact-bound, nuanced issue that has to be resolved usually by the National Labor Relations Board. So they just want to remove all of these protections. The majority wants to remove like half of the protections. And I think that's why Kagan and Sotomayor joined the majority, because the alternative would have been much worse than this.
In practice, like, how is this going to work? In other words, like in the next case, and I own, I own a five and dime, and my workers strike. Like I say, it's before Christmas. This is when I make all my money for the year. The rest of the year is basically a wash, and then I make my profit, which is the case in retail for a lot of outfits. And I say they did not use. I'm going to sue them, because they did not use enough caution in terms of like my business. Like, this is really costing me a lot. This is my one time of the year. I go to state court, and then like what does the case continue, or does the state court kick it up into the federal system, or does the National Labor Relations Board have a means in which to say no? This is argument. Like, what? This seems to like open up a Pandora's box.
Right. So, it used to be, and it should be, that if the National Labor Relations Board proceedings are suspended until the board can come to a conclusion and conduct an investigation.
And to be clear, in Northwest, the National Labor Relations Board did step in.
It is investigating and has been investigating and doing something entirely separate from this litigation. And what this decision says is none of that matters. That if the National Labor Relations Board General Counsel steps in and says, we think this was arguably protected, we're embracing this unfair labor charge, we're launching an investigation, like, it's unclear if that should have any bearing at all on a state court's decision to allow or disallow a civil suit against a union. This is a very much an open question in the case. And how I personally think that this is going to cash out is that it's going to help Republican appointed general counsels to the board stick it to unions even more. Because I think what we're going to see is, the next Republican president will fire the general counsel on day one and put in some horrible anti-union, management side lawyer as the general counsel of the NLRB. He is going to start just handing out filings that say, I don't think this was arguably protected, go at it in the state courts. I don't think that this conduct was protected by federal law. Let 1,000 lawsuits bloom. I think what this does is empower the general counsel to make it easier for suits against unions to move forward in state courts, but doesn't really empower a liberal general counsel to stop those state lawsuits. It's kind of a one-way ratchet, if that makes sense.
Well, could you view this in the same vein as other efforts to undercut the administrative state? And I know it's different than the EPA. Like the EPA is essentially like issuing decrees on environmental protection, and this is more of like a separate body that adjudicates labor law. But in the same way, this is the Supreme Court overriding these agencies that have been around for decades at this point, tasked with these exact issues, and saying, no, we know best, and we're imposing this and weakening you in the process.
Yeah, I would say this is an attack on the National Labor Relations Board when it is in Democratic hands. When Democrats are running the board and the general counsel is a Democrat, this gives state courts pretty clear authority, although the bounds are kind of blurry. The court didn't fully resolve this issue, but some authority at least to ignore what the board is saying, to ignore the general counsel, and to open the doors to lawsuits. But then again, when the board flips into Republican hands, I think it's going to give the general counsel a tool to really lobby in these cases and say, we don't think this was even arguably protected, so the lawsuits can go forward. So yes, it's an attack on the administrative state. It's an attack on the board's authority and the general counsel. But as with so many of these attacks on the administrative state, it only really kicks in, I think, during a Democratic presidency. And as soon as you have Republicans running the show again, the court is probably going to step back and say, wield this power however you like.
Because there's no real like definitional or limiting principle on where the state court can't sort of like intervene. There's no, because I mean, how much more? If it's like, there's really no other answer, right? I mean, it's arguable or it's not arguable. I mean, even not arguable is sort of hard to sort of like establish. The idea was that Congress wanted to give the National Labor Relations Board wide authority under this to make this assessment, and not in any other place, because they wanted to have one clearinghouse. And so just about everything is arguable. But if you start saying this is not arguable, it's definitionally arguable because the National Labor Relations Board is arguing about it right now. I mean, it's like they have destroyed the capacity again, it seems to me, of Congress, even though we don't have a Congress that would do this at this point. But they have destroyed the capacity of Congress to sort of make decisions on this.
I completely agree. And the point you just made is exactly what Justice Jackson said, and said this should have been the beginning and the end. It's definitionally arguable if the clearinghouse for all labor disputes thinks that it is arguable. And so this is yet another case of courts filled with non-experts and partisans and ideologues stepping in and saying, we know better than these members of the administrative state, which is apparently so dangerous, even though the administrative state answers to the president, who we get to kick out of office. These justices are on the bench for life. We can't do anything about it. And yet they are claiming that the separation of powers and principles of democratic accountability requires them to be the final decision makers in all of these disputes.